For order at this institution. Thank you all for coming. 5 years ago, 10 years ago for sure, maybe even 5 years ago, somebody had said, we're going to have a program on Section 3 of the 14th Amendment, not Section 1, not Section 5, not even Section 2, Section 3. My reaction would have been, yeah, and the opening act is going to be the quartering of soldiers in peacetime for sure. But here we are, all of us. And I'm delighted that we have two of my favorite people. As our primary speaker, we have Professor Josh Blackman, who holds the Centennial Chair of Constitutional Law at the South Texas College of Law. He is also the editor of the Heritage Guide to the Constitution, to which I'm a contributor, which makes him, I guess, my boss.
A punctual contributor, I'll add.
Well, since he's my boss, Jed, I'm sorry you're screwed. I'm going to give you more time. And commenting on Professor Blackman, we have our own Jed Sugarman, a treasured professor colleague, and as it happens, co-advisor, a faculty advisor to the Federalist Society here at Boston University School of Law. And with that, I am done talking. Professor Blackman.
So moderate of you. Thank you so much. So just curious, before 2021, did anyone ever hear about Section 3 of the 14th Amendment? No. In your con law class, when you did the 14th Amendment, did anyone talk about Section 3? You do process, right? You do equal protection, maybe you go to enforcement, but you skip over the stuff in the middle. The 14th Amendment has a lot of stuff in it, right? Section 2 involves voting rights. Section 4 involves a debt. But Section 3 is a very curious procedure. Right? I'll read it for you. It provides, take a deep breath, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or any state who, having previously taken an oath as a member of Congress or as an officer for the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. Period. Oh, we got to a period finally, right? But Congress may, by a vote of 2/3 of each house, remove such disability. Let me make this easier for you. There are four sort of components of Section 3 that are relevant here, and they're sort of out of order. I'll start with number one. Who does Section 3 apply to? Not everyone. It only applies to someone who took an oath to support the Constitution in a couple capacities, as a member of Congress, as an officer of the United States, important phrase, or a member of a state legislature, or an executive or judicial officer of any state. Okay, that's who it applies to. So if you've never held any government service, congratulations, you can engage in insurrection, you are fine. Maybe you're not fine, but you can't be disqualified under Section 3. Okay, the second part, what does Section 3 prohibit? If a person engaged in insurrection or rebellion or gave aid and comfort to enemies, right? Number three, what is the consequence if a covered person engages in insurrection? You can't hold certain offices. And it says, no person shall be a senator or representative in Congress, okay, elector of president and vice president, okay, or hold any office, civil or military, under the United States or under any state. Okay, and then number four, Congress has the power to relieve that disability by 2/3 vote. This is a very high vote, the same requirement to propose an amendment to the U.S. Constitution. So 2/3 is very high. Everyone with me? All right. There are four cases in the sort of gestalt of Section 3. And this is based on a recent decision from the Colorado Supreme Court. The first one, can Colorado disqualify Trump using its election laws? Okay. The second question, Trump was unique. He took one oath and only one oath as president, his presidential oath. Never held governmental service before. So the question is Trump's oath as president, as an officer, as a president, so does that subject him to Section 3? Next question, did Trump engage in insurrection? Okay. 4, is Trump disqualified from holding the presidency? That is the presidency one of the positions that you cannot hold if you're disqualified? Legally, these are four distinct questions. Number one, does Section 3 require federal enforcement legislation? Do you need a statute to enforce Section 3, or can state election law provide the cause of action? Second, and here's the key question I'll be focusing most of my attention on today, is the president an officer of the United States? That's the key phrase. Trump is only covered by Section 3 if the president is an officer of the United States. That's the only way he gets in there. Everyone agrees on this point. The third question I will not focus on at all today is, were the events of January 6th an insurrection? I think that's a question for the court of history to decide, but we'll see what happens. The fourth question, again, not going to be talking about today, is the presidency in office under the United States? Different language, officer of the United States, office under. Different phrases, keep those in mind. My attention will be on question number 2. Why? If I am right about question number 2, all this goes away. Section 3 has no bearing on Trump. If I'm wrong, Trump might be off the ballot. So I have to begin with a credit to a friend of both myself and Jed's, Professor Seth Barrett-Tillman. Maybe you've never heard of him. Fair enough. He's a law professor in Ireland who has been writing on this obscure topic for more than 15 years. He said for a very long time the president is not an officer of the United States and the presidency is not office under the United States. Tillman wrote this back in 2008 and onwards, when no one cared about this issue, before Trump, really even before Obama was elected. And he wrote a series of articles that no one really cared about, but I did. This was me before I grew my hair out. I was much younger. You will get old, I promise. It will happen to all of you. And around 2013, I said, wait a minute, this guy Tillman, he's onto something, right? He's looked at the text of the Constitution. He's found things that just we haven't seen before. And to Seth's credit, he got some praise. Will Bode, who is a professor at Chicago, he's been involved in this debate. He praised Tillman's work. He said Tillman's theories make sense of patterns most of us never saw, brings order out of chaos. And that's what we need. We don't want chaos. We want order. And in the wake of the 2016 election, all of a sudden, Seth's work became relevant. Why? It was alleged that Trump's property in Washington, D.C., the Trump Hotel, and Trump's hotel in New York City, the Trump International Tower, were soliciting business from foreign governments. And that these foreign officials, diplomats, and so on, were spending foreign money in Trump properties. And that this money would eventually weep its way back to Trump's coffers. And it was alleged by a lot of people that Trump was violating the Foreign Emoluments Clause of the Constitution. No one ever heard of the Foreign Emoluments Clause, maybe like 3 people, right? But Seth had. And he'd written a bunch with Professor Teachout, who was at Fordham, Jed's former school, saying that, look, this phrase in the clause, this phrase office under the United States, refers to appointed positions, not elected positions. The president's not covered. And Seth and I embarked on a somewhat lonely journey over the course of several years, filing briefs in any court that would accept it, and some that wouldn't, arguing that the president is not an office under the United States. We have lots of evidence, which I won't bore you with. Among them, George Washington accepted gifts from French government. Thomas Jefferson accepted gifts from foreign governments. One piece of evidence we're talking about is a document from Hamilton. Hamilton was asked to prepare a list of all the people holding office under the United States. He put out a list. Washington was not on that list. And I want to give Jed some credit. There was some debate about this. There was another document which suggested that Hamilton listed Washington. We put out some other stuff. And in the end, you know what? I think we were on the same page. When Hamilton was asked this question, Washington was not listed. And if you want, there's a signature. But I give Jed credit. He's a mensch. It's very hard to apologize in the world. And Seth has made more than enough. And I don't stop it, Jed. It's enough. But he's been very good about it. And we have only good feeling for Sugarman. I'm so grateful he's here today. Anyway, so in the end, the couple courts that looked at the issue said, Blackman and Tillman, you guys are wrong. How can you say this? This is nonsense. Officer of the United States, officer of the United States, get lost, go away. The case winds its way to the U.S. Supreme Court, and then Trump loses, right? So at that point, the litigation became moot. Despite Jed's best efforts, they dragged the litigation on forever, right, Jed? So it took literally 4 years. I mean, they sued him. They sued him like a week after inauguration. It took 4 years to get the case to the Supreme Court. Jed and I actually agree on this point entirely. But it got to the Supreme Court like in October of 2020, give or take. And then the court's like, okay, bye-bye, this is moot. And I think that was the right call because he's out of office. Maybe not, but they got rid of it. So Seth and I thought, oh boy, we're done. We're done with this office stuff. Let's go write a book on something fun. We'll just go talk about our times, right? Yeah, but then January 6th happened. And as Seth and I were watching January 6th unfold, we realized we're back in the game. Why? Because Section 3 would only apply to Trump if he took an oath as an officer of the United States, right? We realized this on January 6th. Maybe we weren't the first people in the world to realize it, but probably among the first. We're like, oh boy. So we started writing on that day about this issue, like, okay, this is going to happen. They're going to try and disqualify Trump if he runs again. You've ever seen the movie Groundhog Day with Bill Murray? It's a really good movie, but Seth and I feel like we're living in Groundhog Day, where every day we wake up and there's another officer issue that comes up. This is the obscure, shouldn't matter. So we proceeded to write an article on this issue, and we repeated our position for many years ago, right? That this phrase "officer of the United States" is used in the Constitution to refer to appointed positions. The president shall appoint the officers of the United States. The president shall commission the officers of the United States. The impeachment clause lists the president and VP separately from the officers of the United States. The oath clause says the officers of the United States take an oath. The president has his own oath. He doesn't take one under Congress's supervision. We wrote this article. Got some downloads, but didn't make a big fuss because we said things people don't like to hear, kind of like Cassandra. But some other law professors got a lot more play than we did, and they are fellow members of the Federalist Society. Lest you think the Federalist Society is monolithic, it ain't. So Will Bode and Michael Paulson are law professors in good standing of the Federalist Society, both trained at Yale, which is perhaps their downfall. But Yale's produced some good scholars, I suppose. And they put out this article last summer in August. Actually published the day before, after my birthday. We knew it was coming. They gave us an advance copy, which they didn't have to. I'm grateful for. I thank Will for that. And they came out this paper saying, look, we've looked at this. And across the board, Trump must be disqualified. Every single question. Is he an officer? Yes. Was there an insurrection? Yes. Can the courts do this? Yes. Can he disqualify him? Yes. Every possible checkbox to disqualify Trump, they said yes. And they said it's not even close. They said essentially all the evidence points in the same direction. Trump must be disqualified. I debated Bode in Chicago last week. And I told him, I'll tell you the same, he bent the arc of history, right? But for this paper, I don't know the Colorado Supreme Court would have knocked Trump off the ballot. Jed's nodding his head. Maybe we can't know for sure. So they changed history a little bit. The story ain't written yet because we got more to come at the Supreme Court of the United States. But they did a big thing. But they wrote about us a little bit, and we got some love, I suppose. And they wrote, I'll just read this: the Blackmun and Tillman position. The Blackmun and Tillman textualist approach is hidden meaning hermeneutics. What a good phrase from a St. Thomas professor, of course. That renders Section 3 a secret code, loaded with hidden meanings, discernible only by a select priesthood of the Illuminati. That maybe you need a decoder ring to understand our argument. By the way, I asked ChatGPT to create an image that depicts a secret code with hidden meanings, discernible only by the Illuminati. It wouldn't do it. Even ChatGPT thinks we're too crazy, right? ChatGPT wouldn't even do it because it's too conspiratorial. But this is what passes for academic discourse. Speaking of academic discourse, Akil Marr, who is a professor of both Jed and a few others, and a friend of Gary, Akil took us on his podcast, and he said, let me be clear. I can't do the Akil voice. This is genuinely stupid argument in merits. I'm going to demolish it. It's embarrassing. This is very wrong. It's silly. It's so silly. And I was laughing because I couldn't resist, because even hearing these formulations elicits laughter from me. Ha, ha, ha. And then what happened? The trial court in Colorado accepted our arguments in their entirety. This was a Democratic appointed judge, or elected judge, who was subject to appointment. Not one of our federal side fellow travelers. All right. The trial court judge ruled that if you look at the text of the Constitution, the best argument is the phrase "officer of the United States" means appointed. And I know you probably can't see this, but you went through all four of these provisions, right? The appointments clause distinguishes between the president and the officer of the United States. The impeachment clause separates the president and the officer of the United States. Commissions clause: the president shall commission the officer of the United States. The president doesn't commission himself. The oath clause separates the president from the VP, right? And again, this is not a difficult argument. This is not a secret code. When people say secret code, what they mean is, this is not what I learned in law school. This is new. This is different. And people react weird to different arguments. Like, this is strange. This is unusual. I don't know what this is. This is crazy. This is Illuminati stuff, right? This is occultish. But if you sort of just get past that weirdness argument, everything sort of falls into place, right? The Constitution draws this global divide between appointed and elected officials, right? There's certain rules for appointed positions and certain rules for elected officials, right? These are different positions. Ultimately, the court came to our support. All right. Now, our position is backed up by not just the text, but also history. There is an entire line of cases going really far back which say the phrase officer of the United States means appointed by the president or head of department or court of law. I can give you case after case that says the same thing. It was never considered whether the president's an officer of the United States until very recently, until it had to be for this case. But then we get to the Supreme Court of Colorado. And the Supreme Court of Colorado rejected our, argument. I'm sorry, I skipped ahead too far. The Supreme Court of Colorado rejected our argument, right? And the court said, look, we're not going to engage in some sort of technical, hyper-literalistic reading. We're going to use the ordinary usage, right? The president's an officer of the United States. Was he an officer of France, an officer of Canada, right? What else would be an officer of? An officer of New Jersey? He's an officer of the United States. And he said there's no evidence that people in the 1860s thought this was a constitutional term of art or anything like that. And then the state Supreme Court said, if members use this phrase officer so liberally, someone would have said something, but they didn't say so, right? We won't give this a technical meaning. Okay. So the Supreme Court granted certiorari, and an oral argument will be held on February 8th, which is about 2 weeks, so it's coming up. I'll be in DC. We'll see what happens. As we say, it'll be wild. And Seth and I put an amicus brief into the court. We actually filed our brief about 10 days early. And in turn, virtually every other amicus brief cited us, except for the parties. They didn't really cite us, just briefly, but maybe something's going on there. Our brief makes two primary arguments. The first one I'll just mention briefly. Section 3 of the 14th Amendment, we say requires some sort of federal enforcement legislation. The leading authority of this is opinion by Chief Justice Salmon Chase, who wrote an opinion shortly after the 14th Amendment was ratified. And Chase said, you need Congress to act here. The states cannot do this by themselves. Now, someone always says, wait a minute, Josh, that can't be right. The 14th Amendment self-executing. Not exactly right. If you want to sue the government for affirmative relief, you need a statute. Don't believe me? Go look at the complaint in any 14th Amendment case. It cites Section 1981, Section 1983, or some other statute. Trust me, I pulled the complaints in Brown v. Board, Bowling against Sharp, right? Reynolds v. Sims. I pulled all those complaints. Took me a little while, but I did it. All those complaints reflect that when you want to sue the government for relief, you need to cite a statute. And I think Chase was recognizing this dynamic. When you want to use the 14th Amendment as a sword to seek affirmative relief, you need a statute. But if the government's prosecuting you or regulating you, you can always use the Constitution as a defense, as a shield. So as a defense, you don't need a statute, but as a shield, you do. And here the voters are trying to wield Section 3 as a shield, as a sword, to take Trump off the ballot. But we don't really want the court to rule on that ground. Why? If the court rules that Colorado Supreme Court acted incorrectly because maybe you need a federal statute, that doesn't settle the insurrection issue. It leaves it open. Dare I say, leaves it festering. Jed's nodding. It leaves it festering until Inauguration Day of 2025. And let me just sort of paint this hypothetical for you for a moment. Let's say in November, Trump wins the election, but the Democrats have both seats, both houses of Congress. It's possible, right? I mean, I don't know. None of us know what's going to happen. But let's say that the maps go blue, and then a couple of the Republican candidates, as we often do, flame out in the Senate. It happens every 4 years. Let's say the Dems have the House and the Senate, and it comes up to January 6th of 2025. Again, not January 6th of 21, January 6th of 25. And President Trump gives a speech saying, you better certify my results. And then maybe some prominent Democrats, not Biden, someone says, you know what, Democrats, have the fortitude. Do not accept Trump's votes. Disqualify him. Hold that the votes given for Trump are not, quote, regularly given. This is the key phrase in the statute. that the votes are not given regularly, right? Right. I'm sorry. Wrong slide. Okay. That the votes are not regularly given. That's a key phrase. When I pulled up, it's 3 U.S.C. 15. Hold up. And then Vice President Kamala Harris gavels the session to order, and they call the first state. I think it's Arizona, or is it Alabama? Alabama. Yeah. And you know what? Senators rise and they object, and they say that the votes for Donald Trump from Alabama were not regularly given, and they object to them. At that point, if enough senators do it, they split and they go to their respective houses. And if there's a majority of Democrats, there'll be immense pressure to say that the votes for Trump are not given in a regular fashion because he's disqualified. And there might be the same in the Senate. And they can knock out every single electoral vote given for Joe Biden, for Donald Trump. At that point, what happens? It's actually not clear. So one argument is that Biden will win by default because he has the most electoral votes. Or there might be a contingent election in which the people in the top three are considered, which would be Biden, Trump, and maybe Joe Manchin. Who knows? Could be that the vice president, maybe it's Nikki Haley or Ron DeSantis, can take the oath under the 20th Amendment until Trump is given a pardon or an amnesty from the Congress. We actually don't know. We're in sort of uncharted waters, very, very deep, muddy, uncharted waters, but they're uncharted. So we think that anything short of a ruling on the merits here is a very bad idea. It's a terrible idea. We need finality. And look, I know the Supreme Court's under attack and people will not be happy either way, but ruling now before Super Tuesday is a heck of a lot better than ruling on this in January of 2025 when people are rioting at the Supreme Court in the Capitol, right? We don't want that. So let's get a clean ruling. So we submit that the cleanest ruling is the office of the United States argument. There's precedent they can cite. They can cite Justice Story. They can cite the text. All they have to say is that we've said before the office of the United States means appointed. That's all we're saying. President's appointed, not elected. And the court's not going to say the president's appointed. There's a lot of authority saying he's elected. They're not going down that road. I know some briefs will try, but that's not going to work. So all they have to say is, in a 5-page opinion, the president is elected, not appointed. Office of the United States means appointed positions. Go home, have an election, figure this out the ballot box. And I'll just leave you with sort of one final thought. Will Bode was on a podcast, and I like Will. He's actually a very good friend, and he's always candid. Always candid. He doesn't use sort of Amarian hyperbole. And Bode said, "Look, don't underestimate Tillman, and you really shouldn't." He said, "Argument is the perfect argument, and it's beautiful. Why? Because it only applies to Trump. And this was not by design, but by the circumstances of history. What we're saying here would apply to only Trump. Every other president's held some other office before. All of them, from George Washington to the present. They all did. Every other candidate does. Trump is just this sort of unicorn that became president after having a reality show, right? He had never held government service. I don't know if he even served jury duty. Maybe he did. I don't know, right? But the guy had never taken an oath to the Constitution, right? All right. I am just about at my time. I'm going to turn this over to Jed. I'll leave the text of the 14th Amendment on the screen. And I thank you all for your attention.
Great. All right. Thanks, Josh. Let's give.
Thank you. Oh, I'm taking your chair. I'm sorry.
Thank you. I did not imagine. As much as I was surprised that I would get involved with this debate about emoluments and the officer under the United States, I thought at least I covered that issue. I'm happy that this will never come up again. And yet here we are, and maybe studying presidential power is now a growth industry. So I've appreciated our interactions and mutual generosity, understanding, and I think that one of the big picture things is you can disagree with someone very vocally and publicly, and you can also make a giant mistake that was part of that New York Times article that I and some co-authors made about a document. And yet you can still get together and have a civil debate. A civil officer and a civil and an officer, civil officer and a civil gentleman. Great. I don't know if they'll get that reference from the 1980s. Anyone? An officer and a gentleman? All right. You maybe you got it. Great.
Okay, Boober.
Now I will say I identify as an originalist. I used to identify as a progressive originalist, but now I've dropped that progressive phrase, and I just say I'm committed to originalism because that's what makes law is text and context. So there are some other considerations that come into play, but if the text is clear, my view is that if the text and context are clear, that's binding. Now, even Justice Scalia said that he was a faint hearted originalists. And I'm going to take this opportunity to broaden this conversation and then get into the details about, and given that this is a conversation among a mix of 1Ls, 2Ls, and 3Ls, good to see many of you here from various classes. I'd like to make this an opportunity to think about originalism as a method and how it's quite complicated. And I have to say, there are some points in this debate that are a bit more complicated than I imagined when we started this back and forth in 2017. But while Josh has his PowerPoint, I'm the real originalist because I'm just going to go with old school chalk and blackboard. Actually, they had chalk, but I don't know that they had like the mobile blackboards back in the 18th century. So give me a little bit of latitude. So first, before I get into the methods, let me just give a big picture point. Is that I think of the bottom line about this disqualification question. My bottom line is not that far from Josh's, which is I am a skeptic. In fact, I think all of these disqualification cases are probably a bad idea, partly for originalist reasons about the nature of the courts and about the meaning, in particular the word insurrection. That is the concern that I have, is about the meaning, the original meaning in 1866. They knew exactly what they were referring to when it came to insurrection. If you still have that, right? So if we think about it's not just the word insurrection. It's the text about shall it engage if they engaged in insurrection or rebellion. You've taken administrative law, or you were in my Fed courts class yesterday. You have to recognize that words are known by their associates, nascitur associis. You put insurrection or rebellion on the board, plus the context of the Civil War. There's a very high bar for what counts as an insurrection. But I'll come back to that later. And then give it, and then also nascitur associis or egistem generis. The other kinds of words that to help you understand the words insurrection is that you also have given aid or comfort to the enemy thereof. That's a lot. That's a very high bar. And as much as I think January 6th was one of the worst days in our country's history, and I think President Trump bears moral responsibility, and I've even written about how he has criminal responsibility. And I've written an article called January 6th, Insurrection and an Overt Act Solution, where I drew with a co-author, Alan Rosenstein at Minnesota, from other parts of Article 3 on overt acts, and not that it's a treason case, but my view is that that January 6th prosecution is legitimate. This disqualification is problematic at best, and I think a bad idea, and probably not consistent with insurrection. So that gives me an opportunity from this meaning, the text and context, to take a big step back and talk about originalism circa 2024. So I sometimes describe this, and I'm going to actually, in my legal history seminar this evening, I'm going to give a version of this talk about the significance of originalism's evolution. I call this Originalism 3.0 today. Originalism 1.0 back in the 1950s, I'd say, is where it first emerges, and then really through the 1980s, is more of an emphasis on original intent. What were the policies and specific expectations around the framers and ratifiers of the Constitution? So, for example, when you're trying to understand equal protection, did the Congress that passed the 14th Amendment, what did they do in terms of policy? Original intent, they created DC schools and they made them segregated. So equal protection must mean segregation's okay. That approach was rightly rejected. We don't understand equal protection based upon what they did in the 1860s. We understand it from the words that they chose, that oftentimes they were more aspirational, and if they used more open-ended terms, they were inviting some values and principles that would be applied beyond what they did. Do as I hope, not as I do, is one way to think about why original intent has been rejected. So the next step was talk about original understandings, but that focused too much on the people in the convention, the 1787 Philadelphia Convention and Madison's notes. But the Constitution doesn't become law from the drafting of a Constitution. If Congress passes it, it still has to go to the president, right? And the president has to sign it. So it's not over when Congress drafts legislation. The same thing is true about the Constitution, but it's not the president who has to sign it. It is the people who have to ratify it. So far more important than what happens inside the convention. And this is highly relevant to this conversation about officer. It's not so much what a few lawyers in Philadelphia thought they were doing. And looking at Madison's notes, which, by the way, Madison altered and doctored his notes, for example, to make Hamilton look worse when they went from friends to frenemies to just outright hating each other, okay? So you've got to be a little skeptical about these sources, side note, right? So it matters more about public ratification. Generally, I'll give you there are some exceptions to that. So this concept, the first thing I'm going to put up on the board is original public meaning. So at the risk of being too cute or referring to Coffee Talk on Saturday Night Live, Coffee Talk, there was as Michael Myers' character got a little verklempt. She said, as she was trying to regain her composure, she said, the Holy Roman Empire was neither holy nor Roman nor an empire. Right? So then talk amongst yourselves. Okay.
They have no idea, Joe.
They have no idea. You go look it up. You still have YouTube. Okay. In this case, this argument about officer is neither original nor public nor meaning, and I'll explain why. Okay. So let me give a summary about why not. There is a lack of evidence from the documents of 1787 and 1788 that they had this reference point of officers under the crown on their mind, which is something that is the original, that is the basis of this argument. There are not sources, there are simply not sources in the relevant time period that were referred to and cited. Not the Blount trial is not. I mean, a bunch of these different things that happen they may be. Joseph Story may have talked about them in 1833, but 1833 is not 1787, not 1788. And some of the things that happened during the 14th Amendment debates, they are very loose and hard to read, and they're not specific. There's not specific evidence of this design that holds up under scrutiny from 1866, 1867. So it misses the time period that's relevant. Now, I think that you can look at some other times, but like said, a lot of people rely on the First Congress or things that happened in the 1790s. Is that relevant? Is that probative? Yes, but with a grain of salt. But it doesn't pass the strict test about being from the relevant time, about the specific time period. The key thing that Josh said about the critique from Bode and Paulson is that the word officer was a secret history. Now, generally, right, the default rule is about the reason why we have an emphasis on original public meaning is what did we the people understand in 1788 during ratification or in 1868 during the ratification of the 14th Amendment? This argument is esoteric to the nth degree, right? It is a problem that the argument relies on a highly technical understanding of how the English drafted their own documents, and that was a lawyerly at best, it would have been something understood by a handful of lawyers, and that is not the same thing as what the public would understand. Here's the caveat to that. There is another argument there's another approach to original public meaning called original methods originalism. That turns on when you have a phrase in the Constitution that's a bit more technical. The audience, I think there's a valid argument that things like ex post facto, once it's Latin, even if they had more Latin back then, they didn't have many Jesuit schools around in 1788. And so this was a technical concept. How about Bill of Attainder? I'll admit that when I was in law school and I first read Bill of Attainder, and I kept thinking that it was how one attained something. Is this like due process and takings? Attaining something. I didn't understand that attainder was tainting somebody. So there is a place for original lawyerly meaning, original methods of what lawyers did. This is definitely not one of them. The word officer is, first of all, not a complicated technical Latin term or anything like it. It is not. It is a term of general connotation, general usage, and throughout the Constitution, like in the place where we talk about the president, Article 2, you're introduced to the president and oaths as the president has an office. So the colloquial understanding, any reader during ratification would have this approach to thinking about it. And meaning, does it line up with the text? Does it make sense? Is there a coherent story here? So the other thing I want to think about just very briefly, and this is a conversation Gary and I have been having for a while, is that there isn't enough robust development of originalism as a method about what counts for originalist arguments. Let me just quickly spell out, like, I think there's some burdens of proof that are not met by this argument by Josh and Seth. But on the other hand, I think there's some real problems on the other side when it comes to burdens. And this is why I'm opposed to these disqualification cases. Now, so the burdens are: one, historians, if you're going to be engaged with originalism, you've got to play the game by the rules of the method. You know, in math, right, you've got certain rules, right? In philosophy, you've got historians. This is what I do. And so if you're a historian making an argument, you've got the burden to establish. If your argument is the rise of the negligence rule in torts came about because of X thing that happened in law or society, that's a historical claim, not an original claim. But historians have the burden of making a historians have the burden. These are the burdens here. You've got the burden of making a positive claim. You posit. So, but then when you get to originalism, there's another burden, because it's not just about what Madison thought, proving what Madison thought or proving what happened in the convention. You also have to then extrapolate that to the public, right? And there has to be consensus. So there's kind of 2A and 2B. It's got to be public, B, consensus. It's really hard to prove public consensus from the ratification debates. There are the notes. Madison doctored his notes from the convention. They couldn't, in the state ratifying conventions, they couldn't hear some of the speakers. But nevertheless, does that defeat the enterprise? No, there are I think there are significant areas where the understanding, for example, of good behavior, right? Another example of this is that the word good behavior, even though it doesn't say that judges will have their offices for life explicitly, everyone understood, and it was demonstrated by the ratification debates and reading the Federalist Papers, that having an Article 3 job for good behavior meant you had that job for life. And you couldn't, for example, do what I think a lot of people have proposed, which is apply term limits. Okay, let's just say there's sufficient evidence there about public consensus. But and then I think there's a third step. What is the judicial role here? Is it activist? If it's activist, it has a problem with original public meaning, because in the 18th century and a little bit less in the 19th century, so maybe there's a sort of a ratchet, but if you want to have the courts intervene to, let's say, overturn a statute or overturn a federal statute, or maybe a little bit less, overturn a state statute or overturn a precedent, there is a burden to justify that judicial intervention, because the 18th century understanding of courts and the 1860s understanding of courts was not our modern understanding of full out, robust, post-Warren Court, post-Rehnquist, post-Scalia, post-Roberts Court judicial maximalism, judicial supremacy. So that's a high burden if you want to be active. I think that cuts both ways in this case, because on the one hand, if you're trying to get the courts to overrule Colorado, that is an intervention by the Supreme Court to say, Colorado, you can't do this. On the other hand, it's also a pretty big intervention to say that someone doesn't have a right to run for office and that people can't vote for that person. So I think this kind of is sort of a split decision on this thing. Now, I'm going to shorten this. I have a 4 and a 5, but let me leave them out from here. Okay. When it comes to officer, right, there are a whole bunch of problems when it comes to the text. And that, first of all, that, right, in terms of this meaning, right, as a historical matter, I think it's very hard to prove that officer had this meaning. There's not a lot of evidence for it. But let me just, without going into the details, I just want to make this observation that if you're going to make this argument that a president is not an officer, right, you've got to ignore all of the times, or it's not an officer of the United States, sorry, the officer of the United States, that it creates a problem in a whole bunch of parts of the Constitution. Now, one of them is something I've worked on a lot, the emoluments clause. There is a foreign emoluments clause. Josh, there's also a presidential emoluments clause. It would be, what that presidential emoluments clause is, also in Article 2, that a president can't receive extra pay from Congress or from the states. It would be puzzling that the founders would have a rule that only applied to presidents for state and federal emoluments, but then would have a rule that applied to everybody except the president when it came to foreign emoluments. I don't understand how, I can't make sense of this interpretation, how to make coherent that inconsistency. There's also a debate about incompatibility, that everyone else, that you can't have a job in Congress or have an office in the executive branch. Turns out I've updated my priors. I think there's a plausible story about why that might not apply to the president. In the 18th century, there was a big problem in England among the Whigs that they would have members of parliament both be in parliament and then give them offices and they get double pay. And it was also a problem for having wearing two hats. But that was a very specific problem for people under the prime minister. I think it would be a little weird, but there is a historical argument for it. But the other things that are hard to make sense of is that impeachment, that you could impeach anyone else, and disqualify anyone else except the president. That the disqualification clause would mean that after you impeach someone, you could disqualify anyone else, but not the president, and not from the presidency. That is puzzling. What's underlying all of these assumptions that somehow the president should be treated differently and not as an officer is less about the word officer and more about, I think, a misunderstanding of the word president. This is part of the book I'm writing. The book is tentatively titled "A Faithful President: The Founders versus the Originalists." The larger point here is that we have experienced, without really thinking about it, the growth of presidential power so that the presidency feels royal to us now. It feels imperial, so it must have always been that way. The word president, if you lived in the 18th century, if you thought about what a president was, it was the alternative to a much more powerful official like king, obviously, but governor was the real word for that power. Who were the presidents in the 18th century? The Lord President was a judge who presided over a court. A president had equal power among a panel. It was being a member of something. The first president of the United States was not George Washington. It was John Hancock and some other people you've never heard of. John Hanson, who was president of the Articles of Confederation Congress, who had no more power than anybody else, but he presided over that Congress. The word president, I'm going to now quote another movie from the 1980s. I don't think that word means what you think it means. The Princess Bride, anybody, right? It's inconceivable that the word president might have anything less than a royal style power. That is not consistent. Like Benjamin Franklin was president of Pennsylvania, not because he was governor, but because he was a member of an executive council of 5. So I think the real misunderstanding here is not about the word officer. I think the real misunderstanding here is about the word president, and that we want the president to be something greater than the founders ever intended. So I'll stop there and invite more conversation and questions too. Great.
Thank you so much. You guys are very lucky to have Jed on your faculty. It was Fordham's loss for sure. We have originalism, we have public, and we have meaning. There are 2 phrases in Section 3. Officer of the United States and office under the United States. Let me put them back on the screen like this. The arguments that Jed raised about the emoluments clause, about incompatibility clause, and impeachment disqualification, always language office under the United States. We've always argued from the get-go that office under is a harder road to travel. We think that was a hard road to travel in 1787, and in 1868, it was an even harder road to travel. We've not taken a position on whether in 1868, Section 3 extended to the presidency. Kurt Lash, professor at Richmond, a good friend of mine, he's argued that position. We haven't. In fact, I'm pretty sure if you read the Trump brief, they've abandoned that position, and they come around to our position. The only position we're taking in this case is that officer of the United States. For original, the Constitution says the president shall appoint the officers of the United States. That's pretty good evidence of what that phrase means. The Constitution says the president shall commission the officers of the United States. Fred Marbury, right? John Adams signed the commission, not delivered. There's no absurdity there. The Constitution lists the president separately from the officers of the United States in the impeachment clause. That's all the originalism we need. For public, this was discussed. Justice Story, you're right, was not there at the founding, but he was observing what happened. And he said, it seems to be that the phrase officers of the United States doesn't extend to the president because he's elected, not appointed. That's not evidence of original meaning, so people understood it. And throughout the 1860s, people cited Story over and over again. For public, we found a newspaper in Louisville, Kentucky, in 1868, April of 1868, which said, the president is not an officer of the United States. He cited Joseph Story. He cited the Commission's Clause. The same arguments we're raising here was cited in the 1860s. That's pretty public. This was not a sophisticated legal journal. And for meaning, we have case after case of the Supreme Court saying the president is not an officer of the United States. I'm sorry, that officer of the United States means appointed and not elected. Right? We have case after case. So Jed's arguments, I think, do a lot of work for the Foreign Emoluments Clause litigation. I'm happy to litigate that another time. But for this case, all the court has to say is that we know what officer of the United States means. It means appointed. And whatever else about office under, we don't have to decide that now. And that would be a clean way to resolve this issue. If the court says the opposite, that the president is an officer of the United States, then you have to deal with some stuff. Say, all those other cases were wrong, right? We have to make a caveat to all those cases. And then you say, well, maybe there's some officers that the president doesn't appoint. Maybe he is himself one, right? Maybe he has a commission himself. If the court goes down our road, it's simple. They can cite dozens of Supreme Court cases. They can cite Justice Story. They can cite the text of the Constitution. It's all there in black and white. There's no secret. I'll give Jed office under is a harder argument because it does rely on a British drafting convention that people maybe don't know about today. That applies to office under, not officer of the United States. All right. I want to pause here because I want to make sure we have plenty of time for exchange and Q&A. And so, Gary, however you want to do this, I'll defer to you, sir.
Okay, I'll give Jed one last shot at some rebuttal, and otherwise I will look for hands.
Less than a rebuttal. I will say I appreciate that distinction you're making. The other thing that I left out because I was also trying to keep my time short, but I think it's raised by your response here. I appreciate that you're taking the harder case about officer of the United States. I have an open mind about whether civil officer, right? Want to go back to the
Sure.
laws there about
Sure.
The other thing that I think is even stronger case that I am more open. I'm not persuaded yet, but there's the other.
Oh, you want the Appointments Clause?
No. The Appointments Clause is a huge problem. It's because, of course, in context, the president is not going to appoint himself to something, right? There are blog posts that have raised this, and maybe too vociferously. But and of course, the example here, someone else has mentioned, if I invite you to a party and I say the party's at 8 p.m. and attendance is optional, it doesn't mean that the host's attendance is optional. It's the guest's attendance is optional. Like the host should not miss the party. The president is the host of the party, and the officers are the guests. So of course, this is by natural language. The president appoints officers. It's implicit that those are not the president himself, because that just makes sense of the sentence. But the thing that the officer, civil or military, am I blanking on that in the 14th Amendment? Cannot be
The first sentence, first part.
Oh, right. No person shall be a senator or hold any office, civil or military. I think there is an open question about whether someone could whether the presidency is an office, civil or military, because that is there is other places in the Constitution about salary raising. There is a real question about whether a civil office pertains to the presidency. I'm not persuaded yet, but I think you've taken at least the harder case in this discussion. I'll leave it at that.
All right, questions?
Questions? Anyone? Hands? I don't want to talk. Go ahead.
Well, I guess something that I was thinking about. So, with this conflict between the Appointments Clause and can the president appoint officers, would you say that there's a possibility that it's just some bad drafting that can ambiguity that was a decision?
I think it's a great. Tristan, it's a really important question about the limits, and this really reflects the burden point, which is you've got the burden to show historically, and it has to be a public consensus. And I think there has to be some caution about taking a constitution where there weren't computers and word editing and et cetera, And there's also a problem for textualism about statutes, that given that statutes are 1,000 pages long and no one really reads them, that also begs the question of whether that's good legislating ever, the antecedent question. But it's a cautionary about the reliance on word-by-word textualism, and that's an advantage of originalism. Originalism is not textualism; it's not exactly the same thing. Textualism is highly word-by-word focused or clause-by-clause focused. Originalism asks us to think about broader purposes, and so the Constitution has to be seen through a bigger picture than just a clause that uses the president and officer in one particular way.
So the way I'd respond is like this. Section 3 was not written on a blank slate, right? They adopted language that was used in the Constitution of 1788. So for example, the part about the oath, let me go back to that slide, right? The language in clause number 1 is very similar to the language in the Article 6 oath clause. The language in the third clause is very similar to the language in the impeachment disqualification clause. They borrowed language. We know this. The 13th Amendment is based on the Northwest Ordinance, right? The Privileges or Immunities Clause is based on the Privileges and Immunities Clause. Due process is almost identical to the Fifth Amendment. When you take text from the original Constitution, you sort of bring that old soil with it. So if we were right about how this was understood in the 1780s, right, that officers of the United States meant appointed positions, and they brought that meaning with it. We don't have to show that this was their expressed intentions, right? That's never what originals asked. In fact, that's the 1.0 version that Jed said we've moved past. I say, Josh, how could it be that framers would have excluded the president of all the positions? Every other person who had been president had held some other office, all of them. And I want to lay this out. This is a scenario. A person becomes president, never held office before, engages in insurrection, and then runs for re-election. We didn't anticipate that one 5 years ago. Why would they have? So I think the intention argument actually cuts both ways. I'm with Jeff, with the emoluments. Why would they allow the president to receive foreign but not state? I'll credit him. That's a valid argument. But the intentions one here is actually much harder because it's something that goes beyond the realm of Abraham Lincoln. This was not a question that was on their minds. They had no reason to think about it.
Thank you.
Yeah.
Are there, I guess my question is, how is the term officer generally used in the Constitution? Is it exclusively reserved for appointments and never in reference to elected official?
Right, so this is an area where Jed and I probably don't agree. The Constitution says office in many places, and we agree the president's in office, but there are different types of office. There's officer of the United States, there's office under the United States, there's office under the authority of the United States. There are different phrases, and we argue that these various phrases, officer of and under, refer to appointed positions, right? The Constitution refers to president in office. We don't dispute that, but the definition of officer of comes from our lines, the Appointments Clause.
Article 2, Section 1. The executive power shall be vested in the President of the United States of America. He shall hold his office during a term of 4 years. President takes an oath of office. Now, the point I was making before about public versus technical. If this were in Latin, then there were Latin or I don't know what some other language where you would have to get highly technical about these words, that might be one. But if when you get introduced to the president, when you get to chapter 2 of the story, Article 2, you're introduced to an office. There's a high burden to show that there was some other general understanding by average ratifiers, we the people, that would have this highly esoteric distinction between what an office was and what an office would be.
Now, I'll just say that Professor Blackman is too modest to say that he and Seth Tillman are writing a 10-part series of law review articles going through all of the different uses of office in the Constitution.
It's almost 1,000.
Go ahead and put in the plug.
It's almost 1,000 pages long. It's a lot.
But Josh, how do you handle that original public meeting? I mean, how do you handle the problem that there's no evidence of the public having this understanding?
We don't think there was a need for the public to talk about it, right? There was no need to decide if the president was an officer of the United States in 1868 because who cared, right? You had Abraham Lincoln, you had Andrew Johnson. It was an issue. people talked about Jefferson Davis, and that's an argument on the other side, right? They thought, how can Jefferson Davis become president? A lot of people thought the phrase office under the United States meant the president. No one talked about it. So there's no discussion one way or the other. That's why I keep pointing to this Louisville, Kentucky newspaper.
Was their party affiliation of that newspaper?
Oh, they were Democrats.
And did they have an interest? Did they have a particular interest in that moment about the upshot of that? Or
Of course.
What was it?
Of course, Lincoln said I could lose Kentucky I could lose the Union, but not Kentucky, okay? Democrats were important at the time also for ratification. Of course, this arose in a political dispute, as did everything else.
But the upshot of that dispute was a Louisville Democratic / redemptionist post-Confederate newspaper knew that when Johnson was being impeached, they didn't want radical Republican Benjamin Wade to be the next president. They had a highly partisan, motivated, confirmation bias reason to make this argument. It is not probative. It is not probative.
It is probative because it demonstrates how a lawyer aware of story can make an argument at the time. All of these cases are partisan. When you had radical Republicans in Congress saying, of course the president's office in the United States, those are radical Republicans just the same, trying to sell ratification. When you have congressional debates, these are always partisan debates. That's why court cases are good because judges are neutral. And the judges have said for 200 years that officers of the United States are not elected, they are appointed. If you don't like the Democrats, go look at John Marshall. Go look at Stephen Field. Go look at Noah Swain, all Republican judges.
The only counterpoint to that is this is why original public meaning gives primacy to 1787 to 1788 and not as much to anything that happens after ratification, because you lock in. This is why I'm an originalist, is that we need originalism is the worst form of interpretation except for all the others, right? Because of the problem of partisan motivation, we need some set of methods to bind us to law so that we're not just doing politics. What binds us is the pre-partisan set of rules we make to bind ourselves to the mast, and that happens in ratification. Arguments that happen late, like in this newspaper in 1868 or in the first Congress, have less probity. They're less relevant because then you get partisan actors with a President Washington or a President Lincoln or a President Benjamin Wade on the table that creates certain partisan motivations for how things are done.
Do you presume the meaning was consistent between 1788 and 1868, that all two United had the same meaning, whatever it meant?
No, I think I'm saying that's not relevant.
So then how do you know the meaning 1868 unless you look at the 1868 sources?
In 1866 and 1867 sources, and there are sources that cut the opposite direction.
But this newspaper is from that period. You have to look at that.
So the one problem with that is that by 1868, this was that's late in the debates, and that then gets shaped by the fact that Johnson is currently being impeached at that moment. But
So we have a hyper-technical period, like maybe a 14-month window to look at original meaning. That's if we apply.
I'm saying that particular. It's well understood that newspaper had a partisan motivation for that.
Mark Rick wrote that, didn't provide much backup for it. In fact, the newspaper actually transferred over to another editor shortly thereafter. I'm not sure when it happened. But I think we'll be hesitant for some.
I think if your best piece of evidence is the Louisville Democrat, nothing against Louisville, but if that's the only piece of evidence that says this was a matter of public meaning, that is not a lot to go.
But there's nothing saying the opposite.
Okay.
There's nothing saying either way.
There's one thing saying the opposite.
Let's move to the question in the rear.
I want to try to bring this conversation back into maybe into the broader reality of what the United States looked like in the post-Civil War during the debates of the 14th Amendment, which is, we don't know, there's a lot of conflicting evidence specific to like what specific intents and specific provisions are, but we know that Section 2 and Section 3 of the 14th Amendment are explicitly designed to prevent the Confederacy from rising to power again in a democratic fashion. That is why Section 2 nullifies the 3/5 clause. That is why Section 3 basically creates these sorts of parameters that bar former Confederates from getting elected office. Now, the problem that I have with your interpretation, Josh, is that it contravenes what is the explicit purpose of what we know about these documents for sure, which is to keep Confederates out of office. Now here, you're inviting a loophole where a rank and file Confederate member, say maybe a large booster or a supporter of the Confederate Party, someone who didn't technically have elected office, but was clearly a part of Confederate politics, could then just rise to the presidency otherwise. And I just cannot see a way in which the framers like Thaddeus Stevens and other members of the Reconstruction Congress, right, would even conceive of that sort of possibility And I think that it's a really kind of asinine reading.
Well, 2 points. First, you're talking about the presidency. That is clause number 3, that a person rose to the rank could not become president. We're not arguing that here. Arguing is only about the officer of. That again, a person who had never taken oath to the Constitution before took one oath as president, he's disqualified. So it's a very different hypothetical than yours. But let me explain this. Section 3 was a compromise, right? There were different proposals. One proposal was that if you were a former Confederate, you can't vote for at least federal positions, right? It would disenfranchise them altogether. Another said if you were a former Confederate, you can't hold any office. Well, they wound up with this very technical jumble suit, right? Which says certain people build certain positions, can't hold other positions in the future. That's the language they chose. So we describe as a loophole is actually a reflection of actually the text they chose. They didn't get what they wanted. The radicals wanted to disqualify everyone, disenfranchise everyone. They couldn't. They only got some things. And what language did they use? They used the language from the Article 6 Oath Clause that offers the United States. And that has a meaning. And whether they intended it or not, that phrase has a meaning. This is 1.0, which we've since moved beyond. So your purpose argument, I get it. It works very well for the Kurt Lash argument of why would they let Jefferson Davis be president? I get that. I'm not arguing it. Arguing is limited to the narrow scope where a person with one oath only as president, became president, then engaged in insurrection after re-election. That was nowhere in their minds. And I think you can't use some sort of unexplored intentions to negate what is in the text. Thank you.
Yes.
I was just wondering how the officer of the United States squares with the idea that the president is the commander-in-chief, because it seems like there's a military aspect of officer, and that I'm not sure if this is just a present-day meaning, but if you are the commander-in-chief, it seems like you are commissioning officers and telling officers what to do, and within the military, there are officers that tell other officers what to do. So it seems like there is some military aspect of this, and I just wondering how it squares.
Happy to do that. There's an argument that Kilmar's raised and others. And for example, the impeachment clause says that the president, the vice president, and the civil officers of the United States can be impeached. Bill said, wait a minute, the president's not a civil officer, he's military. I'm not sure which yet comes out of that. I can give you 2 centuries of authority saying the president's a civilian officer. The Supreme Court said we have a civilian officer in charge of the military, top down. That's what makes our country unique. We don't have a general in charge of the country. He's a civilian officer. Alexander Hamilton, in the very document we talked about, was asked to list the civil officers, right? He listed the president as a civil officer. We do not have a military president. Thank God we don't. That would be a very bad thing. If the Supreme Court wants to say that, yes, in fact, the president's a military officer, they're going to have to overrule a lot of precedent saying otherwise.
So is a military officer an officer of the United States, but a civil officer isn't an officer of the United States?
Right. A military officer of the United States receives a commission. Are you in the service?
No.
Okay. Anyone in the service here? I be you that have one, right? A BC that had one. If you're a military officer, you got your commission from the president, right? You're subject to the Uniform Code of Military Justice. This entire raft of things that happen to military officers. The president's not. You're a civilian atop of the military, and that's a structure we've had since George Washington's time. But no, the president's not a military officer. I think he's a civil officer. I'm not sure, maybe Jed doesn't agree, but he's not military.
The very short note about the 1793 letter from Hamilton, despite it being, even if we say that's sort of within the realm of public understanding, there's another explanation for why Hamilton left off president. And
I'm talking about a different document. There's a different document. This was, Hamilton was asked to list the civil role, and he listed the president's civil role, not the military role. This is actually a different document. I'm sorry, Jen.
No,
actually, I misspoke. There are a lot of Hamilton documents in Jen. I'm sorry.
What's the line in the musical? He doesn't stop, right? So
Hamilton.
Yes,
Non-stop.
Sorry, I'm not gonna try non-stop, right? Do people have other questions about there's this complicated self-executing
That
argument
is the question.
and or the meaning of insurrection? Any other?
Let's see if there was anyone who hadn't already asked, but go ahead for round 2.
Yeah, that was kind of what my question was about. So you said that we need like a statute to actually put in effect what Article 3 says, but like, why? I mean, I understand that there's all this precedent where you need statutes, but what's the point of writing an amendment to the Constitution that like you actually can't use?
Well, you can use it, right? Section 5 of the 14th Amendment, I don't have it on the screen, says that Congress shall have power to pass appropriate legislation. And Congress did that. Within a couple of years of ratification, they passed what became the Ku Klux Klan Act, the Enforcement Act, the Civil Rights Act, a bunch of laws that enforce Section 14th Amendment. Today, it's assumed that the courts are going to be the driver's seat of the 14th Amendment. That was not what the Republicans wanted in Congress. They thought Congress would be in charge. In fact, it's a byproduct of the Warren Court that we have such a fixation on the courts, and Jed's nodding. So in that regard, I see Section 1, Section 3 in the same regard. If you want enforcement, you need a statute. And in 1870, Congress enacted a statute which created a protocol called Quo Warranto, Quo-Waranto.
I know Quo Warranto.
And what Quo Warranto says is, who's the real officer, right? You go to a judge, you say, Johnny Rebel over there was a Confederate. I don't think he's really holding this office valid. And the judge can then say, yes, you are invalid, you were removed from office. It's an old it's an old Brit that existed. Salmon Chase, writing in 1869, said you need Congress to enforce this. Now, I will admit this is a very complex issue because this is arising in the context of presidential elections. And we had a case a couple years ago called Chiafalo, it was Washington, it was Colorado. Washington. Yeah, the Colorado Baca, right? And Chiafalo basically said that the states can bind their electors. You can't have the so-called faithless electors. This was Larry's last stand, so to speak, right? If the states can direct their electors how to vote, and indeed the state legislature can say, we're giving our votes to Trump or Biden, they've done that before in the past, then the self-execution question becomes not so important. But I do think Salmon Chase is right. I think the court should stand by Chase and say that if there's any process that's going from Congress, what we don't want is 50 states having 50 ways to knock candidates off the presidential ballot. Colorado goes one way, Maine goes another, New Jersey goes another. I think there's wisdom in Chase's argument, and whether or not he was right as an original matter, he sort of settled the issue. I think it's a good way to resolve it.
So here's another perspective about that. I think this is a tougher issue, but I think there's a different act for it. So Josh says the reason why the 14th Amendment has a Section 5 is to allow Congress to enforce equal protection, due process, privileges, and immunities. That could have been Section 1, right? If the point was to enable Congress to do those things, it wouldn't be in the 5th section of the 14th Amendment. The 14th Amendment has an independent right to equal protection, not being deprived of life, liberty, or property without due process, and privileges and immunities. And they added a section at the end to empower Congress from the get-go. In fact, before there were claims that tried to assert that used the privileges and immunities clause of the original Constitution in Article 4 that were set to self-execute those kinds of phrases. So if the other parts of the 14th Amendment are self-executing, meaning you could walk into state court, why would 14.3 be different? But on the other hand, what Colorado did is highly problematic. A bench trial by one judge in one district. Imagine this happening. I mean, we're opening a Pandora's box. This is my objection here. So one answer to this is the other part of the 14th Amendment answers this problem: due process. You need more robust process. I think it is what the Maine Secretary of State should not be on her own able to strike Trump off the Maine ballot. So you go to court. Is that enough? Well, I'm not sure that the Colorado thing was enough as a matter of due process, because we should all be worried about walking into a district court in the Upper Peninsula of Michigan and getting Biden struck off the Michigan ballot because one judge in Michigan does his or her own fact-finding that Biden committed insurrection by policy at the border, and then we've got chaos in every partisan district in swing states. This is the problem I'm worried about. The one answer is that you need much more robust due process. I think there's a legitimate argument that there has to be a criminal process for insurrection, even though it doesn't say it. It's the way to make sense of equal protection, due process, the Republican guarantee clause, voting rights, is to make sure that we don't have this highly random process of striking everybody off the ballot. And we probably shouldn't do any of this, in all honesty, for insurrections.
All right, maybe we can squeeze in 2 more questions. Let's see. Let's try.
I thought at the beginning that we weren't touching the word insurrection with a 10-foot pole. But now that we're on it, Professor Sugarman, you seem to be getting at this. Insurrection or rebellion, I have it up on my phone right now, is in the U.S. Code. It's a crime. What are we to make of the fact that Trump hasn't been charged with that? Throw in the book at him.
No one's been charged.
None of the January 6th have been charged with that. What are we to make of that?
Go, Jen, you want to do it?
No, go ahead. I think
I mean, look,
you know,
Seth and I wrote a paper very shortly after January 6th about what would happen if Trump was indicted in Section 3353, which was the 18 U.S.C. 3353, which is the statute that you mentioned, which is curious because it says if you're convicted of this crime, you can't hold an office under the United States. What people don't know is this was signed into law by Lincoln before the 14th Amendment. This actually predates the 14th Amendment. We're actually agnostic on whether this is actually enforced legislation, whether a conviction under the statute would amount to Section 3 disqualification, but we think it'd be pretty good evidence of one. So if Trump was actually indicted and convicted of violating Section 1353, 30, whatever, the statute, I think that would be good evidence of it.
but evidence, but not dispositive, because we don't want like in a highly red county in a swing state or a highly blue county in a swing state, selectively knocking people off of statewide ballots with cherry picking districts. I'm concerned that even a criminal conviction for insurrection should not be.
What would do it for you, Ted? What would do it? Paul Randall?
Well, no. I don't think that the original public meaning of insurrection covers what happened on January.
But assuming there was, what process would suffice?
I'm just a commentator on your brief.
Oh, boy.
Let's get one last
We run out of
question.
meaning, as they say.
Well, actually, people, I have to go because I have to be at another panel.
At that other law school, this side of the
So
river.
I'm going to let
The inferior law school.
conversation
Law.
continue if people want to continue the
Thanks, Gary.
conversation. I have to.
No.
And I know you all have classes at what, 2:10?
Yeah, in the back. Yeah, come on.
Yeah, sure. So this doesn't necessarily, I know, go to public meeting, and it's also borrowed from the remark. But there's an exchange in the Senate debates around the 14th Amendment on, I think Senator Johnson says,
Exactly right.
well, why wouldn't the president be included in this Section 3? And Senator Moore interjects, well, see, right there, it says officers of the United States.
And we do not take a position on that one. Trust me, we were aware of that.
Yeah.
Again, Tillman, he saw this all 15 years ago. There's been absolutely no surprises. Even in 2009, he said, I'm not taking a position on whether the presidency is covered by Section 3. So we don't have to deal with that. Kurt Lash does. We don't. And Kurt Lash deals with it his own way. All we have to say is that there's no discussion of whether the president's in office in the United States, except for the one Kentucky newspaper Jed doesn't want to talk about.
I talked about it.
Okay.
I talked about it.
That's what we got.
But wait, maybe I'm not so deep into these. I saw this exchange and I think what's your name? Phillips asking, I thought that was clear evidence from the relevant time period that officer of the United States applied to the president.
That's office under.
And so
Office under.
Johnson pointed to the office under.
Okay, here's the problem. Office under the United States should be an easier point for your argument than officer of. But this is so essential. The word under as opposed to of is driving this different meaning. Is exactly what I'm talking about with the burden on original public meaning. It's just too too picayune. It's too esoteric.
Okay.
Yeah.
All right. I think we're out of time. People pack in, but I'm happy if you come up and ask us some questions.
I know, right, that's right. Good. We were invited to go say hi to, if we could leave within a couple of minutes.
Yeah.
Say hi to Mila upstairs.
Oh, I'm
We're getting
happy.
our dinner, but-
Happy